Okay. We will call to order the meeting of the Chicago Board of Election Commissioners for Thursday, March 12th, 2015, sitting and for the purpose of the canvass of returns and proclamation of the results of the February 24th, 2015 municipal general election held in the city of Chicago. Good morning, everyone. My name is Langdon Neal. I'm chairman of the board. Seated to my left is Commissioner Marisol Hernandez, and unfortunately, Commissioner Richard Cowan is ill and will not be joining us today. The first item on the agenda is the consideration of tabulated statement of returns and proclamation of results of the canvass of election returns for the February 24th, 2015 municipal general election held in the city of Chicago. For all those that are visiting us today, maybe for the first time, this is not our regular board meeting. The purpose of this is simply to approve the canvass of returns and the results and officially proclaim the results of the last election. I know there are those that want to speak to various issues, so maybe I will, rather than proceed with the only item on the agenda, which is the proclamation, I'll allow public comment at this time because I think it is germane or relevant to the ultimate decision that we make here today. So, Mr. Means and Mr. Casper, do you wish to say something to us today?
Yes, if I may. My name is Richard Means, along with Andy Finko. I represent Tim Megan, who is a candidate in the 33rd ward. Here we have discovered, with the counting of the provisional ballots on Monday and with the counting of the absentee ballots on Tuesday, that the numbers are showing in a very unusual fashion, so it raises an issue as to whether a supplemental or runoff election will be called in the 33rd ward. By one method of calculation, there would be a supplemental election. By another method of calculation, there would not be a supplemental, and it's my understanding that the board staff is recommending to the board that you use the methodology which does not call for a supplemental.
And that's our usual and customary means of approaching the election results.
Of course.
Yeah.
And because this is the decision as to which method of calculation you use drives the ultimate result, and because this is a matter that has not been argued to the board in these circumstances this year before, we would ask the board to consider our argument that the appropriate method of calculation is to count, just like you do when you're determining the number of petition signatures required for a nonpartisan aldermanic candidate and so forth, under 10.3 of the election code, that you consider total votes cast. That would include votes which were cast by voters but were not counted and tallied for the benefit of a candidate who was entitled to be on the ballot. Such votes would be things like undercasts, overcasts, a write-in for a person who was not a certified candidate. The purpose of a supplemental election or a runoff election is to give the candidates and give the voters an opportunity so that the person who is eventually elected and going into office has a mandate. This isn't a plurality election. This is an election in which 50% plus one is required. And I should be candid with you. I have done a bit of research on this, and I know Mr. Scanlon has, and I'm sure Mr. Casper has. There is not a reported case that I'm aware of. And we had a similar case in 2007.
Correct.
And I argue it before this board with the same personnel on the board, and with Mr. Scanlon and so forth. But that was a case in which there were 178 early votes, grace period votes, absentee votes cast for a candidate named Ambrosio Medrano, and 4 days before the general primary election, the Supreme Court issued a supervisory order saying that you shall not consider Mr. Medrano's vote. And I'm certain that we had argument about this, and I'm certain that the board considered and spoke about the very direct order from the Supreme Court indicating that those votes should not have been counted in determining whether or not there would be a supplemental election. We don't have that this time. We have the unusual circumstance where the numbers appear that by one method there's a supplemental and by one method not.
But this isn't really, I'm going to just interrupt you for a second.
Sure.
This really isn't unusual, because these facts, as you want them applied to this race, would apply to every race
certainly.
that occurred on February 24th. It just so happens that this was a close race,
Yes.
such that if the method were applied that you're asking us to do, it would affect whether or not 50% plus one was achieved.
That's right.
Oh.
Yeah, it's not brand new circumstances. Right. It's just relatively unusual that we get in this gap where one method would drive one result and a different method would drive another under the same set of numbers.
Mm-hmm. And Mr. Means, I'm just, how do you square the language in the municipal code with your argument claiming that the language in 510-3 should apply? Because the municipal code specifically states that the candidate receiving a majority of the votes cast for alderman in each ward at any general or special election shall be declared elected. I'm confused.
Well, yes, let me explain. The majority of the number of votes cast include those votes which were tallied for a person who was on the ballot or for a person who was a certified write-in. It also includes those votes which were cast but were not counted for one reason or another. The voters were presumably valid voters, but they cast a vote for two candidates instead of just one. They purposely decided, or for whatever reason, decided not to cast a vote in that for a particular candidate in that race, but they cast their vote in that race. Okay. And I know that this is a little metaphysical, and yet the appellate court says that using this methodology is correct when you're determining the number of petition signatures required. And the court has said that in Merz versus Volberding. It's a matter of confusion to all of us, and we need to look carefully at it. But because the purpose of a runoff or a supplementary election is to make sure that we have a candidate with a strong mandate, it seems to me perfectly consistent that we use the interpretation of total votes cast, both in the situation where we decide how many petition signatures are required and also in this situation. And we have the easy opportunity to do that because in 6 weeks, there will be, or now 5 weeks, there will be another election. And then we will be certain that there is a candidate with that mandate.
To use your words, let's talk about the metaphysical for a second, Mr. Newton. So logic would say that you're asking us to consider the non-votes for the candidates in determining the results or whether or not a runoff is called for. So if someone comes to the polling place and for whatever reason decides essentially none of the above,
Exactly.
they have decided they don't like either one. Because this isn't a situation when we used to have the punch card system where we had undervotes and overvotes and things like that, and it was a question of whether the voter's intent was. That's a different issue.
Right.
This is clearly a voter comes and says none of the above. Why should that person's selection influence the result of the election? In other words, whether there should be a runoff or not.
The reason is that that is a vote cast. That is a choice presumably intelligently made and purposely made by that individual. And because the attempt is to get, the intent of the law is to get a candidate with a mandate. And by having a runoff, you're guaranteed to have a candidate with a mandate. You should therefore count even the vote for Mickey Mouse, the failure to pick a candidate, the failure to make a valid mark. For example, they might make a mark that's, with a red pen or
That's
something.
really not what
like
we're
to
talking
count.
about here. I want to be careful about that. That's a different situation because that gets into the voter's intent.
Yeah.
I'm going to press you a little bit more, Mr. Beans. Really, you're saying to me, or saying to the board, we should consider the votes of those that say none of the above in making a decision on the results of the aldermanic election.
Yes.
And I respect that tremendously and appreciate your legal arguments. But I can tell you, I have a hard time, just as a matter of policy, making that leap of faith that someone who's elected to say none of the above, their vote should influence the results of the election.
And it's essentially a no
Yeah.
vote.
It's
It's a vote
Yeah, whatever. Yeah, no, yeah, whatever you want.
against the leading candidate. And I think I join in the chairman's response. That bothers me, that if someone decides, I'm going to vote for mayor only, and I'm not going to vote for a particular candidate in the aldermanic election, that essentially what you're saying is it's going to be a no vote against the leading candidate.
Right.
And
Yes.
Yeah.
that
It's problematic.
concerns me.
Yeah.
Oh, and I quite understand.
Yeah.
But we ask the board to keep in mind that the purpose of the statute is that the person who is eventually elected will have a strong mandate. And because we have this available, we believe that you should lean to this methodology in order to guarantee that the eventually elected candidate will have a mandate.
One
Go
other
ahead.
comment, because the municipal code section it just says a majority of the votes cast. It doesn't, I don't see where we have the word mandate, strong mandate. And I think it's just taking it to another level. Your argument, I can understand it, but what the municipal code says is the candidate receiving a majority of the votes cast. for aldermen, in fact. So it's telling us to count the votes that are cast for aldermen in each ward. It doesn't say, you know, anything about a person who decides not to vote for alderman in a particular ward.
I understand
Yeah.
that we're asking the board to break new ground and to make a difficult decision. We believe it's the correct decision. It is consistent with the law as interpreted by the appellate court in Mers versus Volberding, in the way that you decide how many petition signatures are required. And so we believe that this is a fair argument, and the methodology that we are suggesting goes to serve the purposes of the supplemental election.
Thank you, Mr. Means. We always respect your arguments. It certainly, you challenge us to look at things always from a different lens, and thank you for that argument. Intellectually, it's fascinating, frankly. I may not agree with you right here, but I find it intellectually fascinating. Mr. Casper, do you want to say anything?
Very briefly, Mr. Chairman, Commissioner Hernandez, thank you. I too appreciate the creativity of Mr. Means' argument. So let me get this straight. There are 2,000 people who vote in a particular ward. 999 vote for all. Under Mr. Means' theory, if one candidate wins 999 to nothing, there has to be a runoff. Yeah, that's not a majority of the ballots cast. That's his theory. 999 to nothing out of 2,000 total votes cast would require a runoff. That is not what I think the law intends. It doesn't make any sense. In this case, there were 3 candidates. What if 2 out of 3 get 0 votes? How do we determine that? We have a coin flip? What more mandate could you have? But that's the math that Mr. Means suggests. I agree with you, Commissioner Hernandez. The statute says total votes cast for aldermen. There's a reason for that. I didn't do the math to see how many more runoffs there'd be if we adopted Mr. Means's approach. I imagine it would be quite a few. So I think that the only reasonable interpretation is that majority of the votes cast for alderman means a majority of votes cast for alderman. An undervote is not a vote cast for alderman. It's a vote cast for clerk and treasurer and mayor, but not a vote for alderman. And I think that's why we differentiate these things. And so a vote cast is there's a definition of a vote in the election code, and if it's not a vote, then it shouldn't be counted because the statute says you take a majority of the vote. So I agree with the analysis that you all have mentioned, and I respectfully disagree with Mr. Means's approach, and I would urge that you continue your practice that the board has had as long as I've been aware of it. The majority of the vote cast for alderman means exactly that.
Thank you, Mr. Casper. Yes, ma'am.
Hi. My name is Bill Monroe. I'm a resident of the 33rd Ward. I
Yes,
was
ma'am.
also an election judge in the 4th Precinct of the 33rd. For this ballot scanner, it was not coded, as far as I could tell, to pick out the ballot if there was an under or over vote cast in any of the races this election. To me, this means that if someone cast an undervote or an overvote, they were not given the sort of second chance to say that, yes, indeed, that when pointed out by the election judge that they didn't vote in a particular race, do they want to make sure that that ballot is cast? Yes, or you voted for more than one person in a particular race, we can accept your vote, but it wasn't, will not count in that race. I don't know if that's germane in this argument or not, but I just wanted to present that.
Fine, and I think I'd like an explanation from
Yes.
Ms. Bateman.
The undervote option was on, I'm sorry, rephrase that. The overvote option was on, it's on at every election. Therefore, if it's a vote for one contest and a voter votes for more than one, the ballot will kick out as an overvote. Undervote, no. undervote is only on, the law only allows for the undervote to be on at elections where there's statewide candidates on the ballot. So no undervote. So if you didn't vote for either of the three candidates within that office, the ballot would not have been rejected as an undervote. But overvotes, absolutely.
That if it were entirely blank.
Yeah, if you didn't vote for anyone on the ballot, the ballot would have been rejected as a blank ballot. But if you voted for some offices but chose not to vote for one or two, it would not have rejected it for an undervote. But overvote absolutely was turned on.
So your point is relevant.
Is your
Though-
relevant?
Is relevant. Though, again, and that's why I was referring, and maybe you picked up on it, to in the days of the old punch card system, where there was a real question as to voter intent, and then these issues get a little bit blurrier for me. I don't think we had any, from looking at all the election, any issue of any concern that somehow there was a large number of undervotes throughout the city that would indicate that the voters were somehow confused or the equipment wasn't functioning or something of that nature. But it's relevant.
Right.
It is
So
relevant.
When you mentioned intent, that's what
Yes,
where I
it-
yes.
It is relevant. It is possible that someone simply didn't mark it correctly, but unlikely, in my opinion. All right. Yes, sir.
Hey, how you doing?
Good.
My name is James Matthew.
Yes.
Like last time I was here, I was talking about election judges.
Yeah, so, Mr. Macklin, you're here to talk about Republican election judges?
I mean, yes, but then, okay.
Okay, but we're going to stick with issues that relate to the canvass of returns at this time.
Okay.
I won't adjourn the meeting without you having an opportunity to speak.
Okay.
Okay. Any other comments from those that have come down? And we appreciate it, and thank you for coming down and visit us. I encourage everybody to come down and visit us at any point. But at this point, if there are no other public comment, okay, yes.
My name is Catherine. I'm a resident. I was a poll watcher. And what I'm concerned about is that you're not counting write-ins. That's my understanding, that write-ins are not counted in the numbers. And I think that if that's not happening right now, you should adjust that, because our race was so close that could have made a difference. And the same thing, and the other thing I would like you to just consider is that more people that came and voted, it was under 50% voted for Deb Bell. So you would be declaring a winner to someone who got less than 50% of the voters that came to vote. So that is something to consider.
That's the argument, yeah.
Exactly.
Yes.
Were there any write-in votes cast in
Yeah,
this
I'd like
election?
to
Just
know.
curious.
There was no candidate filed a declaration of intent to be a write-in
Right.
candidate in the 33rd Ward, which is a prerequisite
Yes.
for counting any write-in votes. It's not a valid write-in vote unless a candidate files a declaration of intent to be a write-in candidate by the statutory deadlines. That did not occur in the 33rd Ward. So there are no...
That's yet another legal hurdle, to your point. It's under the state statute. We don't make up the rules here. We only follow them. You have to file a declaration of intent to be a write-in candidate for us to consider them. That prevents someone from coming and saying Mickey Mouse, Jethro Bodine, and a few others we've had over the years, and in fact influence an election. So there are safeguards there, Ms. Pence. Okay.
I don't know if Mr. Scanlon has any comments regarding this.
Oh, I'm sorry.
Quite all right. Well, Mr. Chairman and Commissioner, I appreciate Mr. Means' argument. One of the arguments he made is that the statute, which is 21-26 of the Municipal Code, regarding elections for aldermen and the phrase of majority of votes cast should be tied to the methodology for computing signature requirements, cited the MERS case. And the MERS case relied on Section 10-3 of the Election Code.
Right.
And the language of Section 10-3 is actually quite different than the language in section 21-26. Because in section 10-3, it says that petitions shall be signed by not less than 5% or 8% of the number of persons who voted. Number of persons who voted, not the number of ballots cast, or not the number of votes cast, but the number of persons who voted. So that's quite a different situation. So I don't think MERS really controls in this particular situation. And, you know, as far as the issue of counting ballots that are not otherwise valid votes for a candidate, you know, you cited Mr. Meese cited the Medrano case. But we also have to keep in mind that following Medrano, there was litigation in federal court in the Seventh Circuit U.S. Court of Appeals in a case of Parra versus Neal at 614 Federal 3rd 635, where, you know, the court considered the effect that the board, in proclaiming the results of the election, in that case it was in the 25th Ward, did not count those ballots that were cast for Mr. Medrano because the Supreme Court had directed that they not be counted. There was also an argument that the board should count some write-in votes, but in that case, there was no evidence that there were actually write-in votes, valid write-in votes that were cast. And so the board did not include those in the canvass results. And the Seventh Circuit agreed with the approach that was taken by the board in that case. There was also a case, United States Supreme Court case, you may want to look at, Gutierrez versus Ada, A-D-A, at 528 U.S. 250. It's a 2000 case. It involved a case arising out of Guam and their statutes with regard to their election for governor and lieutenant governor. And that statute had language very similar, not identical to the language found in 21-26, where it refers to the majority of votes cast. And the argument in that case was that the election authority should include votes that were not cast for governor and lieutenant governor, and such things as overvotes and undervotes. And, you know, the court considered the respondents' arguments in that case that basically the methodology should rest on a number of ballots cast at the election, not on a number of votes cast or counted for these specific candidates. And the court rejected that argument and essentially said that you don't look at ballots cast. You know, the respondents were trying to essentially rewrite the statute. And they said, you know, the statute doesn't say you count ballots. It just says you count votes cast for those candidates. And I think the section here we're dealing with 21-26 follows very similar to the statute that the Supreme Court construed in the Guam case. And so I think that the board's usual and customary practice of computing the election results and determining whether or not a runoff election is necessary, I think that that practice is consistent with not only state statute, but with relevant case law construing similar statutes. So I would, it's my belief that the board should continue with this customary and usual practice in terms of determining whether a supplementary or runoff election is required.
Thank you, Mr. Scanlon.
If I may, in very
Go
brief
ahead.
response to Mr. Scanlon, it is correct that MERS versus Volberding was decided on 10-3 and not on 21-26. But I believe that while the words aren't the same, the intent is synonymous. In the federal cases, in Parra versus Neal, Judge Dara ruled and the appellate court agreed that this was a case where there were cross motions for summary judgment And the plaintiff's attorneys didn't even bother to deny the allegations in the counterclaim. And for that reason, the plaintiffs lost, not for reasons of substance, but for reasons of pleading. And that was affirmed by the appellate court. So I don't think that speaks to the question before the board.
Okay, thank you for a lively discussion and an intellectually stimulating one. But at this time, I will take a motion to approve and adopt the tabulated statement of returns and proclamation of the results of the canvass of the election returns for the February 24th, 2015 municipal general election held in Chicago. Is there such a motion?
So moved.
I will second the motion. Further discussion? Hearing none. All those in favor?
Aye.
Opposed? That'll be the order of the board. Thank you, ladies and gentlemen, for coming down. We appreciate and respect your position greatly.
Yes.
And as Mr. Means knows, we can always be overruled if the court should decide that we're not approaching this correctly.
Thank you. Thank
Okay.
you.
All righty. Mr. Macklin, you're here to talk about Republican judges of election.
Yes.
Okay, yes, sir.
Okay, what it is that, from the last board meeting that we had,
Yes, sir.
that I had submitted ones that were not selected to be election judges, or...
They didn't get the card.
They didn't get the card.
Yes.
Or they weren't even selected at all after we submit their forms in on time.
Right.
Now, it was over 500.
Yes.
We had, that was not selected, period. And we encountered the same thing with February 24th. Like, some of the people even got their letters 2 days before the election
Okay.
and everything. So we're trying to figure out how can we remedy that situation.
So Mr. Macklin, at the last meeting, you had promised to provide for us a list of those names.
Mm-hmm.
We have yet to receive those. from you.
Yes, I did. I submitted them. And
who did-
what I'll do
Didn't
is,
receive
I'll
We
do it
got-
over again.
Who did you submit it
We
to?
got an email today at 7:07 a.m.
Is that the one?
No, it's, we had another one. But what I'll do is
Okay, no, but I want to know, when did you submit it and to whom?
I'm not push, I have it written down at the office. But
Okay.
what I will do is, I'll personally bring it down here myself instead of emailing it or anything else.
Okay.
A list of all the names.
Address it to Ms. Bateman.
Okay.
Right,
Yeah.
I never received anything from you the last meeting.
Okay.
And then, because remember you copied a stack for me as well. Remember, some of those were,
I did not copy anything.
someone,
Joan Agnew did.
okay.
That's Miss Agnew
I
did. She's
remember
not here today.
Okay. I remember.
Right.
And it was, some of those were not selected as well.
Yeah.
So what I would do is just, would you want me to bring the original copies? Copies of the applications with me, or just names?
Ms. Baton?
I guess the copies, go ahead.
I
Ms.
mean-
Bateman.
Well, you're two different things here. First of all, we want the list of people who served in November,
Mhm.
but were not sent a letter asking to serve in February.
Okay.
And now the second thing is you're now saying you have some applications
Applications.
that you want to submit.
I mean, the applications we have submitted,
Okay,
they were never contacted or selected to be an election judge. And we submitted those same ones from November that was selected for the February election, which was not, they were not selected over again.
But the number isn't as large, though, because some were selected.
Some,
We
it's
talked
not
about that.
as large, but it's
Right.
still,
We're whacking away at it.
I mean, it's
Right.
still,
Yeah.
because,
All right.
at the office that I'm at,
Yeah.
we deal with several different wards.
Yeah.
So I'm submitting maybe 500 or 600 at a time sometimes.
Right. So if you could actually make copies of those.
I have copies of every application
Okay.
that we bring into our office.
Ms. Bateman.
So, all right,
And we'll be able to analyze it.
okay, thank you.
Thank you, Mr. Mack. Yes?
Sharon Maroney speaking, and actually this board has sent an email to us today or yesterday stating that you were not going to supply the Cook County Republican Party the list of judges, and you were all copied on that email from Audra. That is, we are protesting that vehemently. Number two.
Okay,
no,
let me just stop there so we can, do we know anything about that?
You were all copied on the email.
From Audra?
Yes.
I don't,
I got your emails.
I have a copy of it if you would like to see it.
Well, you don't have to, I
Yeah.
mean, she can forward it to us.
They all fell out, but I'll be happy to give you a copy right now.
No, I don't need to, want to read it right now.
Well, the other problem is that she states that you are hiring OTC judges, and you currently have 500 Republican judges that have been certified as a supplemental list in November. So now they would be certified as part of the chairman's list, and this board has failed to contact any of them. And this is causing for voter suppression of the Republican vote in the minority wards.
Okay.
And I do not understand why this board is systematically refusing to accept Republican judges for the Republican positions.
Ms. Maroney,
I'd like
Ms.
AJ to
Maroney,
speak on it as well.
okay, do we have any?
This game that you
Okay,
say that you don't have isn't true.
I'm asking for a response.
We have reviewed applications that have been submitted to us. We did in fact use some of the applications for February 24th. What we are doing now is we are using, when we assigned for, or they're all assigned for the 2-year period, confirmed. Whoever served on February 24th will now serve again on April 7th. In areas where we had judges who did not serve, we are going back to our surplus. We're looking at the committeemen and the party applications first to try to fill those vacancies. If we cannot find through those applications anyone to fill the vacancies, we will go to our surplus, which is our over-the-counter. But we are looking at the party applications to fill whatever vacancies, and we don't have that many because, again, the judges who worked on February 24th are returning on April 7th. So we do have a small number, unfortunately, that did not serve, and we are going to the party applications first to try to fill those vacancies.
That is not supported by Audra, who is the head of the department's email. Who
Well, Audra reports in
specifically
the
said
statement,
that
so,
she's hiring the OTC. Hang on just 1 second. And furthermore, these judges have been certified. We went back. First of all, they were certified in November. You ignored them. We came here and we complained about it in November more than once. Then these judges who have already been certified now should be part of the chairman's regular list in February. You failed to contact them. We personally called 500 of the judges and have proof that you did not make any attempt to place them. In the meantime, you were placing over-the-counter judges who primarily have no relationship whatsoever to the Republican Party in these positions.
Do you know whether of those 500 people, they all indicated that they were willing to serve
Yes, sir.
outside of precinct?
And we documented that.
Yes.
They, anywhere in the city?
Yes.
Because,
I mean,
okay,
myself,
It's not
dealing with
accurate.
the office that I'm at,
yeah.
we asked them, do you want to work outside? They says, yes, they do. Now, like on February 24th, we had a lot of people that, I'm sorry, not a lot of people, but some of the precincts didn't have any of the Republican judges at all that wasn't even, asked to be a judge in some precincts, so we were missing some judges.
Yeah, they didn't
And
show
a
up.
lot- No,
Right.
some didn't show.
That was
We had-
that was a real problem.
But some
Yeah.
that was not even assigned.
Right.
That's right.
So we had to appoint people on the spot.
Yeah, let's just work with your information that you're
Mhm.
gonna get us,
Mhm.
and then the next time we get together, we'll be able to
All right.
report on this.
the end of the
What I'll
month.
do is,
But
I would do is, I would get with her.
Yeah,
And we'll probably sit down together
Right.
and go through each and
that'll
every
be
one.
fine.
Is
That'll
that
be
fine?
That's fine, that's fine. Just in general, yes, ma'am.
Yes, my name is Adrienne Wright, and I would like to
Good
speak
morning,
to,
Ms. Wright.
good morning. I would like to speak to the same issue. I personally recruited judges to serve, Republican judges to serve in the 7th Ward.
Mhm.
I made copies of all the applications. I came down, I did the appropriate thing to get them placed. We knew how many judges were, how many vacancies were in the 7th Ward. These individuals indicated, although all of them did not live personally in the 7th Ward, they were very clear that they were recruited to serve in the 7th Ward. We placed them. We thought everything was copacetic. And 2 days later, that was on January 28th. On January 30th, we find out miraculously that 28 over-the-counter applications have come in, all asking to be Republican judges in the 7th Ward. And I find that very incredulous that anybody would want to do that. I also find it, so I was not pleased with that. The ones that did get placed in the 7th Ward were individuals that I knew personally, so I kept a very vigilant eye on those individuals. However, only two of the 28 that I recruited for the 7th Ward ended up serving in the 7th Ward. The rest of them ended up serving all across the city. I was not pleased with that, nor were they pleased with that. I too see a pattern, for whatever reason there is, of the judges that we are recruiting for particular wards not being placed in those wards. I also served as a poll watcher at various nursing homes in the 7th Ward. I have a great ear for listening, a great eye for observing. And what happened in those wards, and the chatter is that the Republican judges are being placed by the Democratic committee persons. They've all, they talk very freely around you, and they've all said, oh, we all Democrats here. Albeit a nonpartisan race. That is what's happening. And that is why we are, with the Republican Party, are recruiting people who we know have ties to the Republican Party, because without a balance, there is no democracy. That's number one. What I saw in the nursing home was the violations were so egregious that I called on February 23rd to report all of the judges, both Democrat and Republican, because again, the Republican judges were not placed by the Republican Party. And they were all committing acts of electioneering and voting for the residents.
Okay,
And
Ms. Wright,
I did complain. I'd like to know where that complaint is right now to Dawn Downs, because I don't think that any of those votes in those nursing homes should be counted, because they were not cast by the voters, but by the judges. And I don't know any election law that allows a judge to vote for the individual, not to assist, but to vote for the individual. And if they did assist, they must fill out the form, and those forms were not filled out as well. So I just think that we have a couple of things going on here, and I'm for a fair and judicial election, and we're not having that. And if we don't have any balance, there's no democracy.
Chairman, we're gonna pull that information because of the nursing homes. This is the first thing I heard of that.
We'll look to see where that complaint is, okay?
Because
And we'll
everything should
report.
be registered, so.
Well, I think
And we had attorneys up here on that day also, so I need to figure out what's going on.
That's a travesty. That's the first time that the Executive Director Goff is hearing about it. Because I certainly can't speak on that, but I did make the phone call personally.
That doesn't mean,
and
wait,
put-
Ms. Wright, doesn't mean it's not being investigated.
I know, I just said
He
that.
doesn't, he
said-
can't hear he can't know everything, okay?
I'm just saying that
Right.
it's.
We have
it's
1,400,000 voters and a lot of complaints, so we'll report to you on that later.
I just,
When you mean later, we have an election coming up, and early voting for nursing homes is fastly approaching. I would not like to see the same egregious acts mimicking themselves.
We won't have it this
So
election.
I just want to know where we are with that.
We're gonna do that.
But a couple points. Of the people you recruited, did you submit those names to the chairman of the party to submit to us?
I submitted them to, yes, I did.
Okay,
And I-
so the applications came with a party, chairman of the party, Mr. Delmar's signature on it.
His approval and his knowledge.
His,
But it's-
that's
it's not
just,
the
I'm just saying to you. I'm suggesting to you, because this is the statute of Illinois, that when you work hard, and thank you for doing that. Listen, as I have said here many, many times, my first, besides following the statute, is for quality election judges, Q, not DRR, Q. I want them to be knowledgeable, I want them to be informed, I want them to be fair, I want them to know how to do their job, and most importantly, I want them to show up on election day. And I'm having thousands and thousands of judges not show up. I go to my own polling place and it's short of judges. What's the first thing I say to myself? Langdon? I wish I needed a Republican. I wish I had a Democrat. No, I need a judge who knows what they're doing. So our first problem as citizens of Chicago, in my opinion, is that we get, on election day, 15,000 people show up and know what they're doing. Okay? Then we'll get, then we have to follow the statute. But I think it's a more serious problem right now that we're all facing. Nevertheless, it doesn't mean that we don't follow the statute. That's the one point I'm going to make. Your investigation, I lost the other point I was going to make, other than to
Well, I-
use your.
Yes,
they had to stamp
I want to get the gentleman
on-
behind you
Yeah.
and
Hi, my name is Carlos Trigger from the 6th Ward.
Carlos, I'm sorry?
Carlos Trigger,
Trigger.
Trigleeth. Commissioner,
Yes, sir.
we went through this thing about the judges, but I made a decision in my own heart until we get some new civil service staff at the board who are not so-called corrupted by some committeemen and aldermen. Until that, maybe we will get substantial change. But that's gonna have to go to court and probably will be. On the actual election day, as a judge, I wanna bring up a certain point. We need to do an audit